My case has been denied. Should I file a motion to reopen or a motion to reconsider? In this video, I am going to be talking about standards of motions, okay? We'll talk about the standard for the motion to reopen and the standard for the motion to reconsider, and whether or not you should just start over or you should consider filing those motions, either one or both, if you meet the eligibility requirements. My name is Bijoux Ngwanda. I'm an immigration lawyer based here in DC. I do work with individuals across the country and around the world because we're dealing with US immigration laws. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please do not forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, please go ahead and share, like. Do not forget to comment below. If you need a consultation, please schedule your own consultation and using the link below in the description box. You can also call 22751-2180. Consultation fees apply. When you call, just say that you need a consultation so that I can call you back. If you're just asking for questions, I'm not going to call you back because consultation fees apply. So you have to be more precise, like I need to schedule my consultation so I can call you back, okay? And also, before I forgot, please follow me on Instagram. Why? Because on Instagram, we're talking about employment-based immigration. We're talking about business. We're really only focusing on the business side of immigration. Please follow me. Again, link in the description box, because you really want to learn more. Maybe you can help somebody that really needs those type of petitions. We are really going in details, explaining and answering questions. Really, it's gonna help if we go that Instagram page as fast as we can, especially that here we have 11,000 people, so we can get there at least faster than we thought. Come on, you can do it. Motion to reopen or motion to reconsider. First of all, when you get your denial letter from USCIS, the first thing you do is you read it. You have to read it. Sometimes when you get it so upset you don't want to read it, yeah, we get it. Just leave it there, then come back to it maybe 2 days later, read it. Once you read it, you will understand the reason why it was denied. Most of the time, USCIS will lay the facts, then the reasoning, then the conclusion as to why the case was denied. Now, the question becomes, should I file a motion to reopen or a motion to reconsider, or both? Motion to reopen, the standard is that you have to have a new set of facts supported by evidence in order to file a motion to reopen, okay? For example, let's say that it's a marriage-based type of petition. You went to the interview and all that, and the green card got denied based on public charge. And you look at the requirement for income for the sponsor, you feel like, okay, they deny it. Yeah, they might be right because the sponsor is not making as much as the sponsor is required to make, above 125% of poverty guidelines. So now what you can do, you can just get a new sponsor, a co-sponsor, and add their income and reopen. Now you have a new set of facts. You have a new sponsor. Now you meet the requirements. Now both sponsors actually meet the requirement for income, and that makes you meet that requirement as well. So now you have a new set of facts. You can reopen your case, okay? Motion to reconsider. What is the standard? Standard is that USCIS must have made a mistake of the law in order for you to be able to qualify to file for a motion to reconsider. Well, with motion to reconsider, you really have to know the law so that you can, in order for you to accuse USCIS for making a mistake of law, you must yourself know the law, right? If you don't know the law, then you consult with a qualifying attorney so to explain to you whether they made a mistake of law. Another example, still with public charge. That's a case we got earlier this year. USCIS clearly just made a mistake. I don't even know why they made that such a dumb mistake, but I guess the person was just tired. They denied based on public charge, again stating that the income requirement was not sufficient. And we look at the case, we just laughed because the guy was making $85,000 a year, okay? With a family of 3, that's beyond and above poverty guidelines, beyond 125% poverty guideline, as required by our federal government and as required by USCIS policy. So we just had to really file the motion and say, look, you made a mistake, just fix it. This person really make that amount of money. You can't just deny based on public charge. It's so clear. That's just like a mistake, and fix it. But unfortunately, you still have to pay for the fees, the attorney's fees, and the form fee. So we had to do that. We did it, and USCIS reversed themselves on their decision. But guess what? We had to follow up, because what happened was when we filed that motion to reconsider, the motion was granted within 3 months, right? And then the case was just, the green card case was just sitting there. 2 months later, we don't see the green card. We're like, look, this motion was actually granted. Why we don't see the green card? So what happened again? USCIS failed to send that case, remanded that case back to the original office so that they can grant the green card. That was just like like delay, not necessary really, to be honest, but we had to follow up because, you know, still your obligation to follow up, otherwise it's just gonna be delay and you're just gonna waste your time. So we had to follow up, and then USCIS moved that decision and remanded that case back to the original office, and the green card was granted. As simple as that. Mistake of law, motion to reconsider, new set of fact, motion to reopen. And if you have both, you meet both standards, then both motions can file on the same form. Again, you check mark this and you check mark motion to reopen and motion to reconsider. So that's how you deal with denials. But sometimes you can't just file the motion to reopen or motion to reconsider because it's a difficult situation, okay? For example, let's say the application for naturalization gets denied. This is another case that I consulted with a client, and it got denied because of, you know, good moral and character. Remember that when somebody is applying for naturalization, one of the other requirements is the person has to have been a person of good moral and the character 5 years preceding the application, the date of the application. But this person again was involved in some type of misdemeanor convictions, DUI, and etc., driving under influence and stuff like that. So the best solution in that case is like, you know what? Get rehabilitated. Take some classes of rehabilitation based on your level of alcoholism, and then give it some time. At least give it another 4 years. Then when we go back, we're not gonna file a motion to reopen or reconsider. We are just going to go back and start a new application. And at that point, we can prove that your moral and character have changed. They have improved. You took classes about alcoholism, you got rehabilitated, and sometimes those convictions get like expunged as well, or just like get faded because of a lapse of time. So in some cases, you just have to wait and for you to apply later, or you can just start over, depending on the case, right? So that's how you deal with denials. You don't get discouraged. Of course, you're human, you get discouraged, disappointed, but you don't get discouraged because you still have to fight for your benefits as long as you live, right? Especially if you have options. So if you need a consultation, again, 227-551-2180, you can schedule your own consultation on your own time by clicking the link in the description box. Until next time, bye-bye.